Welcome to today's webinar. We are going to be talking about hedge fund due diligence from a couple of different perspectives. I think I'll spend the first half talking about some of the ERISA issues. Many of you know us for our ERISA capabilities and the presence of benefit plan investors in a fund or an investment by a plan into a hedge fund raises some very specialized issues for the fiduciaries and the broker-dealers that are distributing. And then I'm going to talk a little more generically as well about broker-dealer due diligence and investment advisor due diligence as well. But first, just a little perspective. Why are we talking about this today? And I think the answer is that we're seeing a lot of hedge funds, private funds in the marketplace. They tend to be positioned to generate, higher returns. People are looking for those higher rates of return or non-correlative assets. There's a lot of activity around these complex investment products. I know that the SEC, for example, and FINRA are looking very carefully at, I'll use the term hedge fund interchangeably with private fund, looking very carefully at these funds from a variety of different perspectives. For many years, the advisors to those funds were exempt from registration. That changed after Dodd-Frank. But there have been a number of cases brought in this area against hedge fund managers and the brokerage firms that facilitated distribution of those hedge funds, for a variety of reasons. And I think it's illustrative. It's a little bit illustrative to kind of see what some of those cases were. There's been a case where a portfolio manager had some, believe it or not, actually had some inside tips and used it in the marketplace. There's been some false advertising, false representation, just facilitation of improper loans between affiliated products, some improper principal trades. So the SEC has been very active in this area, as well as with FINRA in terms of moderating this. So that kind of gets back to my point today, which is that some significant due diligence is called for when one is thinking about providing hedge funds to clients or making the investment directly if you're on the plan side or the investor side. These are very complex and sophisticated products with very intricate layers of fees involved. And as many of you know, the SEC and FINRA within the last year or two have come out with a few announcements on special considerations for complex products, for hedge funds, have identified this area as an area of priority for enforcement. So it's definitely something that's under scrutiny from the regulatory point of view. And we'll talk first about the ERISA issues. As I mentioned before, when you have pension plan assets involved, it just adds another level of regulatory overlay, which is manageable if you understand it, but it's very complex. So you need to be considering questions such as whether the private fund into which the investment is made holds plan assets, which is a term of art. And if they do, what does that mean? Is the investor that you're working with into a hedge fund, is it an ERISA plan or a benefit plan investor? What does that mean to your investor? What does it mean to the broker-dealer distributing? What does it mean to the advisor of the private fund? And on top of that, of course, you have a litany of regulatory requirements under the FINRA rules for broker-dealer and more generalized rules under the Advisors Act that we'll touch on a little bit. So there's a lot goes into the distribution and review, the due diligence of these funds. So let's talk first about ERISA. It's probably the most mysterious to those of you who are listening in today, so we'll deal with it first. And what we see in our perspective here at the law firm, we work with sponsors of retirement plans, we work with broker-dealers, financial institutions, and there's been a lot of change. People are looking for and accepting more in the alternative class investments, i.e. investments that are not, traditional asset classes. They're looking for, more diversification, higher returns, non-correlative returns. So there's a market, if you will, for these assets to come in. Then the question becomes, well, are they are they plan assets, and what does that mean? Because you have to ask yourself, if the fund into which you are investing holds plan assets, does ERISA apply? Then you trigger that other set of rules. So you have to be aware of that if you're recommending the investment or the broker-dealer. As anything else, there are definitions for assets, and there are a lot of exceptions. I'm not going to get into a big discussion of the exemptions here, other than to note that mutual funds, by definition, aren't deemed to hold plan assets because there's not a look-through rule. So there's kind of a carve-out there. There's also a carve-out for publicly offered securities. But the two common exceptions that we would deal with probably in the private placement of a fund, and one would say, gee, is that fund deemed to hold plan assets or not? We'd be looking at the operating company exemptions, where maybe the fund's a venture capital operating company, or it's a real estate operating company, where if 50% of the investments measured at cost or in operating companies or real estate assets, and the fund exercises control over those assets. There's just several layers you go through there to deem whether or not the exemption applies. And then probably the most common one, I always call it the 25% test, is a test that the ERISA implications of a fund, the ERISA implications of a fund that's deemed to be holding plan assets are triggered as long as 25% or more of the value of each class of equity interests are held by, quote, benefit plan investors, which is a term of art of its own. And what happens when what are the consequences of investing in a hedge fund that has ERISA assets and plan assets, are that you have to be thinking very heavily about the fiduciary duty rules, not only as the investor going in, but the advisor to the fund, high standard, and which brings in some specialized limitations on self-dealing and prohibited transactions. There'll be some reporting and disclosure requirements. There'll be some special rules, separate and distinct from what we know under the Advisors Act regarding incentive fees or other forms of sharing profits. And and there's a host of other ERISA rules, such as bonding requirements, for example. So under ERISA, any individual who exercises authority or control over the assets is going to be a fiduciary. That clearly includes the fund manager or a private fund, a hedge fund, a private REIT. If you don't satisfy these standards, if you're a fiduciary and you break one of the rules, you're going to be personally liable for losses. You have to unwind the transaction, return profits, statutory penalties imposed by the DOL, potentially up to 20%, parallel excise tax provisions under the Internal Revenue Code. The courts can take some action. You're also a little bit hamstrung here because there's certain ERISA rules that apply to limitations on indemnification and other risk-shifting kind of provisions in a contract. So there's a lot to work through. So the implications can be fairly significant, and they also play through as to how you make indemnification and standard of care kind of representations in the offering memo or the operative agreement. So if I'm a broker-dealer looking at distributing one of a fund through my network, I'm an advisor talking about one of these funds to my clients, I have a lot to think about when I get into the nuts and bolts of a fund. It's not just their return on assets or profitability or success in the industry. There's a legal overlay that needs to be considered. A lot of people get hung on. I'm not going to spend a lot of time in the ERISA duties. I know you already have heard me or my other colleagues in the firm speak about them before. The duty of loyalty, the duty of care, the duty of diversification. And that's kind of interesting because a lot of times a hedge fund will have a sole purpose, a concentration in a particular strategy. So, that fund in and of itself might not be diversified. So I think the investing plan has to be thinking whether going into this investment will somehow take it out of its own requirement to be diversified. So you want to be careful in terms of how that's presented and what kind of representations are made. And of course, a duty to follow the plan documents. Some of the other things that come up, you need to be wary of, co-fiduciary liability. The fund manager might be co-liable along with the plan for certain things. And there's clearly a duty to avoid prohibited transactions, which involve many of the standardized transactions that a fund goes into. So that's where you're looking for QPAM exemptions or other exemptions that will cover those standardized transactions, the extension of credit, lending money, sale of property, things like that. Of course, the fiduciaries have an additional set of prohibitions and against self-dealing and what have you. So there's a lot there, and I think that so I think one could say that in addition to the specific duties and prohibitions involving conduct and prohibited transactions generally, ERISA imposes on a plan fiduciary some additional requirements that go to the manager of the private fund as well as the plan sponsor. Very specific disclosure requirements, bonding requirements, and these are all interlaid with recent pronouncements from FINRA and the IRS and the SEC. So it's all converging and making it pretty darn hard. But nonetheless, there's a huge flow of capital from retirement plans into these vehicles, and that's why people are as focused on these investments as they are. I think some of the more common issues that we see in this area are, number one, we see a lot of issues with incentive fees. I mentioned earlier that there's a slightly different set of rules in the Advisors Act with regard to performance comp and incentive fees as compared to what you get with the ERISA application of those. And the ERISA area is a little bit, there's some published guidance, and those advisory opinions are specific to the fact pattern that's set forth. They're not regulations per se. They've kind of become the de facto standard, and then maybe there's some room to maneuver in and around those a little bit, but you have to think about both sides of the incentive compensation world, the Advisors Act securities law side and the ERISA side when you're evaluating these products for compliance. Clearly, you're looking for affiliated transactions, transactions between the investment manager and its affiliates in the plan, because ERISA is written in a way that pretty much bars every transaction between a plan and a related party unless it's exempt. So it's very circular. Nothing is permitted unless it's specifically added back in. One of the very common solutions to this problem is the acceptance of blind transactions. That was actually written back in the legislative history of ERISA, where blind transactions are deemed to be okay. So that would be all right, through a broker-dealer where neither the buyer nor the seller knows each other's identity. And ERISA, as a statute, has taken that concept and expanded it, to include a lot of, if not most, arm's length exchange transactions. You're also looking for the QPAM transaction, which I think I've spoken about in some other webinars, qualified plan asset manager, or even the service provider exemption under ERISA Section 4 or 8B17, which is helpful. So there's a variety of ways to move in and around the exemptions. Some of them overlap. We need to make sure that the transactions of the fund are going to be covered. Because unlike the Advisors Act, where you can pretty much disclose your way to a good place, ERISA transactions, as you know, are per se prohibited. So you either have one or you don't, regardless of intention, or regardless of how much knowledge is provided in the way of a disclosure. I think there's also some issues on the securities side in terms of securities execution. A private fund manager can't deal in a transaction as a principal, but there are various exceptions available for, affiliated brokerage or cross trading, securities lended, sometimes with affiliated investment products. So again, it's something you have to work through very carefully, and on your due diligence, you have to be very knowledgeable of ERISA in order to work through your review of the product. Something that came up in the last couple of years, kind of interesting from the private fund world, was kind of the notion of potential control group issues, and that's where when you apply the control group rules to a fund and its underlying companies. So, for example, a REIT that was buying up real estate companies or a private equity firm that was acquiring businesses. If the fund acquires a controlling interest in one of these companies, the fund might be considered to be part of the control group, just like being the parent company. And that might turn on whether the fund is itself a trade or a business rather than a passive investor. But there's been some court action on this, and I guess last year or a year or so ago, the U.S. Supreme Court refused to hear an appeal. This is back in 2014. Refused to hear an appeal from a decision from the First Circuit, which had held that a private equity fund with an investment in a portfolio company that was managed by the fund's general partner would be considered a trade or business with liability for that portfolio company's withdrawal liability from a union pension plan. The implication becomes one, that a fund investing in an operating business might be exposed under ERISA to a host of pension benefit or welfare benefit plan, liabilities, which typically is something they hadn't thought about before. So that's another issue you need to be very careful about on the private equity side. That can play out with medical plans and with all the uncertainty and potential exposure under the Affordable Care Act. That's especially important these days. Larger employers with 50 more employees are subject to penalties for failure to comply with the employer shared responsibility rules. And then, of course, like anything else in the qualified retirement plan world, just, pension plan obligations, underfunded liabilities, just general coverage and discrimination rules, that stuff is generally looked at on a controlled group basis. So if you inadvertently end up in a control group situation for ERISA purposes where you didn't think you would be in one, that's something you need to be very careful of. So basically, I think what that really means is that when you're a broker-dealer looking to distribute a plan, when you're an advisor thinking about recommending a private fund, a hedge fund, a private equity fund, what have you, if you're a plan fiduciary looking to make a direct investment, looking at these products, there are just some very specialized issues that you need to be aware of in addition to your normal due diligence that come under the penumbra of ERISA. And like I said, the best examples of those that we typically see are confusion around incentive fees and carried interest, and maybe some of the securities transactions around cross-trading, and just general affiliated parties in the deal. So that's what I wanted to tell you on the ERISA side. Now, in terms of swinging around to some other aspects of due diligence, thinking a little bit about just the broker-dealer perspective. Obviously, you're a broker-dealer, you're putting a product on your platform, you're going to conduct due diligence on it. And what we see in the hedge fund world, sometimes a product might have an ERISA component to it, it might not. Clearly, the importance of product due diligence is huge. There's been a lot of, as I said before, FINRA has stepped up its published guidance over the years on due diligence review and concerns about complex products, hedge funds, complicated fee structures, what have you. So it's really on you to be careful when you're looking at these hedge fund products, to be thorough and diligent and to know the kind of questions to ask. Sometimes we'll see some, because of the way they're distributed as private offerings, you want to make sure you want to be checking your securities compliance under Reg D, just in terms of the general sales practices and whether or not you're reaching out to the right kind of accredited investors, or whether you're fit for whether the issuer, if you will, the promoter, is in the right place as a safe harbor for an exemption registration. Clearly, you want to be thinking about the anti-fraud provisions under the securities law that are applicable. Any broker-dealer that recommends a security in a hedge fund is under a duty to conduct a reasonable investigation about that security and to kind of vet whatever the issuer is telling you about it, in the private placement memo and elsewhere. You have to step back and also think about suitability. Think about all the changes and all the heightened developments in the world of know your customer and suitability just in the last 2 or 3 years on the FINRA side. And now try to apply that matrix to kinds of complex private funds and private products that are coming through. It's a challenge. It's very doable. You need to be very careful and methodical as to how you do it. And you want to be looking, you want to be making sure, questioning, what's the status of your relationship with the issuer? Is there any kind of affiliation there inadvertently that might influence your due diligence or create some sort of conflict that needs to be disclosed? Who's writing the private placement memo? To what extent are you relying on your own lawyers or someone else's attorneys, one of the other parties in the transaction? To what extent are you relying on that information? Can you rely on it? Are you getting good reps and warranties about the accuracy of that information? You want to make sure that you're training your own personnel internally as to how to sell and work with and qualify investors for these products. You want to qualify your customers as to eligibility. You want to be very wary of the anti-fraud provisions, under the securities law or FINRA rules in terms of how you offer the documents or make available the sales literature. You want to keep good records of everything, and you really want to document your investigation. You want to make sure you have good procedures in place for how you vet these products. You want to be looking hard, of course, at the issuer's paperwork, their financials, their management. What do you think about the deal? What does it look like as a business proposition? What kind of assets do they have, and so on. So there's a lot there, and those are some of the things. I'm going to go through a little checklist a little later on. But those are the kind of things you want to think about, from a legal perspective, in addition to the business bona fides of the transaction. Now, I think we just spoke for a moment about broker dealers. On the advisor side, if you're an advisor, where do you stand in terms of vetting these, hedge fund products? And probably the best piece is there was a very good piece put out from the OCIE, the Office of Compliance, Inspections, and Exams from the SEC, a little over a year ago, very beginning of 2014. If anyone wants a copy of it, let me know. And basically, they summarized their best thoughts on investment advisor due diligence, where you're working with, selecting an alternative investment, and the manager, the manager of that investment. So, because when you invest in a hedge fund, it's not a product that lives on its own. It's being managed by someone else. And the SEC went out and really took a hard look at advisors, including pension consultants that were recommending these products, and they sort of came up with a scenario as to what they made some observations, if you will, about the industry and where some of their concerns were. And they noted things that it was good that advisors were seeking more information and asking harder questions, in their view, directly from the manager. They liked the idea that sometimes people were trying to put these into separate accounts for better control over the asset. They understood that advisors are often relying on third parties to either supplement a PPM or to maybe to vet the process. We as a law firm are sometimes asked to conduct specialized due diligence for an advisory firm or a broker-dealer firm on a product. And so the question became to the advisor, how well did you trust Steve Wilkes? What was your reliance on Steve Wilkes and the Wagner Law Group to do that for you? But I think it's generally evidence of a good process. So they noted areas of concern in terms of the ability to look not just at the numbers, what's the principal investment, what's the projected rate of return, what are the fees, but to get a little deeper, to look at things like on the operational due diligence side, to really take the time to look at the legal documents, to really understand investment fund redemption terms and liquidity. And that's one of the big things that we see also. People are really baffled and sometimes on liquidity and side pocket deals. You really need to know how to ask the right questions and review the documentation. Because a lot of times, there are various preferred classes of interest, sometimes with different liquidation rights or redemption rights, and that's thrown some investors off skew before. Sometimes people like to see an on-site visit, hard look at audited financials. Are there audited financials? Why not? How long has the advisor been in business? What's the general risk in this industry that you're going to? Are you running it yourself, or is the fund really outsourcing a third-party administrator to implement the deal? So there's some very, very good material in the published SEC OCIE material dated, I think, January 28th, 2014, and it provides a really pretty good working checklist for, on the advisory side, what they've seen advisors doing, and implicitly what they want to see the advisors doing. Now, let me, as we approach here, as we come up toward the end, so having said all that, I mean, you're looking at all this stuff, and everyone realizes that there are legal issues and legal conditions have to be satisfied. Your business common sense tells you want to know if it's a good deal or not. Does it make sense? Is the risk-reward ratio proper as one that you'd want to distribute or recommend? Is it right for your investor? But we've worked on a lot of different due diligence checklists for people, and let me just give you an example of some of the kind of questions that we've raised. I put this into sort of an amorphous list for broker dealers and advisors and direct investors. So these are all kind of merged together. But we'd like to know, obviously, who prepared the information. Is it coming just from the issuer, or was there a third party that's involved? We'd like to get some background information about the issuer, the fund promoter, how long have they been around, who are their affiliates, can we see their documents, do they have a business plan, can we find them on Google or in the newspaper, do they have any references in terms of their business presence, do they have any annual reports, who are the principals, what are their particular backgrounds, how are they compensated, the principals, what kind of relationship, is the principal invested in the company? If so, how much, what's the ownership? Are there any loans or special compensation deals in place for the principal group? We take a really hard look at the PPM, and not just the legalese, of course, but the investment objectives, the performance returns, identification of risk factors, what kind of assumptions are they making in order to make those numbers. That can be buried in there sometimes. What are the general contracts and agreements that are out there that might be in place involving this deal in terms of, again, management, employment, financing, any mortgages. Who's the competition? Who else is in this space, and what do their deals look like? What are the terms of those deals? What are the relative strengths and weaknesses of this product versus the other product? What kind of assets does this firm have? Again, audited financials, projections, capital structure. We like to get a sense of litigation history of the firm and its affiliates and the principals, if they've had any. Are there any non-compete agreements in place with those principals? What are their material contracts? Are there any history with the government in terms of regulatory? Is this the first time they're in this? It might be a well-known name, promoter or issuer, but is this the first time they're in this particular industry or space? Is it someone famous for manipulating, or I shouldn't say manipulating, excuse me. Is it someone who's famous for investing in different currencies? Are they making their first foray into real estate? So regardless of their expertise in the currency world, I want to know what they know about real estate. Is it licensed? Are all the compliance items checked off? What vendors are they relying on? So on and so forth. How do they describe the suitability of this product? What kind of investor, aside from the fact that they have to be, eligible investors, depending on the exemption. What are the special risks that are unique to this product? What are the special advantages that are unique to this product? Break out those fees. Who's paying who, and how is it being shared? Follow the dollars. See, just so you can really understand it. Do they have the right? If you're a broker-dealer, do you need any special training or any additional expertise or support in order to bring this product home to your clients and explain it properly? And on and on and on. We can come up with a million questions. Can your platform support this product on a trade basis to the extent that it has any kind of trade? Some of these items aren't very liquid. They're not going to be trading, if you will. Other funds will have securities that trade. Can you work with them on your platform? So that's an example of the kind of questions they should be asking on the broker-dealer side, the advisor side, and potentially on the investor side if you're going straight in. So those are our thoughts on hedge fund due diligence. It's kind of a specialized world. When ERISA is present with plan assets, that just adds an other layer of complexity, but they're still complex products in and of themselves. So regardless of where you sit on the transaction list, regardless of what your role is, it bears very careful scrutiny. So thank you for letting us share our thoughts on that with you. We'd be glad to be helpful or answer any questions. Just let me know. We'd be glad to let you know what our experience has been in terms of the right policies and procedures for handling private funds, hedge funds, some of the hot issues we've seen and how we've resolved them. Feel free to let me know. Our next webinar in the investment management law practice of the firm will be on April 16th, the day after tax return filing. Everyone will be hopefully breathing easy by then. And what we're going to do is we're going to talk about cybersecurity policy and procedure and really what goes into a cybersecurity policy. There's been a lot of activity in this area, a lot of discussion, but we're going to get right down to the basics, and rather than talk about the generic need for policy, we're going to really work through and talk about what are the key components of a prudent and appropriate cybersecurity policy if you're an investment advisor or broker-dealer in today's world. And that'll be on April 16th at 4 o'clock Eastern Time. On behalf of the Wagner Law Group, thank you very much for joining us today, and I hope you enjoy the rest of your day.